Yeah, if you guys haven't tuned in or seen it yet, you know that YSL trial is going on, man, and it's just something crazy that's going on out there. I think today was like probably the final straw, probably in this case because it's such a wild case. A lot of errors made by the prosecution, a ton of errors. And now, the biggest thing is this gentleman, Woody, that they got, YSL Woody. He was a terrible witness on the stand, both for the defense as well as the prosecution, but more damaging to the prosecution. So he, they had some type of ex parte communication where the YSL Woody had met with the prosecutor and the judge behind Young Thug's lawyers' backs. So it's really a bad situation for the prosecution. This case has gone on so long, and it's reaching a level to where whatever the case is, it's looking like Young Thug, he automatically should have a mistrial in this case. We've watched the whole thing live, and it's been really nutty. This is we're talking about the YSL case, the Young Thug case. They had an explosive witness on the stand. It's going on live right now. It stopped for a minute for them to go into recess. They're in chambers, but if you guys know anything about cases, the prosecution is in really really big trouble. A YSL trial is going on, and it's looking like Young Thug, he might actually get off on this case. Again, this is fully explosive. YSL trial live in Atlanta. Young Thug is about to beat this case. This case is about to be beaten. It's been going on for how long now? This case has been going on for like a very long time. I'm tired of seeing Young Thug on the television. I mean, let that man go, man. This case is falling apart. Atlanta District Attorney has made the biggest mistakes, very big errors. And yeah, exactly. This case is long as fuck. I mean, wrap it up. Young Thug not guilty, man. This case is falling apart. Their star witness has falling apart. This YSL Woody, he gave a big interrogation statement. He admitted to a lot of crimes, and let me tell you, this guy is a faulty witness. If you watching the trial, you gotta tune into this. Young Thug, he's about to get off this case.
Well, I've been in jail most of that time, so
Did you all speak while you were in jail?
a few times.
So your friendship didn't stop once you just because you went to jail.
What you mean?
Did your friendship stop just because you went to jail?
Who
Or
determine when a friendship start and stop?
I guess you would.
I will.
Yeah. So did your friendship stop, or your coolness? Because you said coolness. Did your coolness stop with him when you went to jail?
Well, in jail, out of sight, out of mind. One day I probably called or something. I don't.
Okay. You have permission to approach?
Hey, Judge. Sir. I'm hot. Can I take this sweat off?
This guy just came on television. He's now telling the judge that he's hot. He's hot in court and he needs to go out. This guy is a maniac. He just blew this case for the prosecution. You guys are gonna see a mistrial in this case. A mistrial, is simple. The errors of the prosecution, Atlanta, Fulton County District Attorneys have made so much errors in this case that this case is not possible to go on. It might end here today, right now. And I'm praying that it ends. I've had enough of Young Thug. I don't want to see it anymore. Young Thug, get off my television. Get off my television. This guy, this witness is terrible. YSL Woody. He's supposed to be the star witness for the prosecution. So if you guys don't know what this guy is supposed to bring, YSL Woody, he's supposed to testify to a drive-by shooting, okay, where he claims that Young Thug gave him the order to do this drive-by. This is how they connect Young Thug to the entire case. This is how they connecting him to the entire case. This is it's really out of control, and it has to end. It has to end. I believe they're coming back. They're coming back. They are coming back. This is it's insane, actually. It's actually insane. The judge is now accusing this guy of lying. He's accusing Young Thug's lawyer of stealing the information from him, from his chambers. This case is a nightmare. This case is a nightmare. Believe me when I tell you, this case is a complete nightmare.
I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt. I understand. I don't want to be held in contempt. And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You act like it's ex parte under
It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked the Samba court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get your information?
But just listen to what I'm trying to tell you.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not something substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it, 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not
Sir,
sure.
I don't want to hold you in contempt, but this is that serious.
Judge,
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based upon information and belief,
From whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
But you're assuming something because I told you already.
well then, other than
Answer
if
that.
you were sitting in
Woo!
with a recorder,
This is crazy.
or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that was a privileged communication. It shouldn't have
Well,
been.
it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a
When I got
I'm
this
not gonna have any
information-
further- I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I don't know what information happened outside our presence. That's really it.
You can go into custody at this point.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a
And when-
witness outside our presence.
And whenever, yes, I have an ex parte conversation,
And-
which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside our presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for another day.
in the first place? I didn't know about this stuff.
That's
I raised
for
it
another
before
day.
the
So,
court. I raised it as soon as we found out about it.
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele,
But you're acting like it's
Mr. Steele, that is not when
Woo!
the case when
The judge is stuck.
somebody discloses
The judge is stuck.
in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read the case, I'm assuming you read it. That's what it says. And you did it.
The
supposedly.
state wishes to be heard.
You said it supposedly. And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6, and I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind
You
anything.
can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there and you're eavesdropping. So you can't use something ordinarily that you had no business business getting to begin with, and then stand on, well, hey, we didn't give you the information, or a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why are we
yeah,
But that is not the issue.
that needs to be told, but
But right now, we don't know
Mr. Steele.
why we were excluded from that.
Mr.
And I
Steele,
want that
stop.
information.
Just stop.
Williams, constitutional right of the
Just stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1
because
says
you've already said that. You've already
the
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, ma'am, Ms. Love.
Witness intimidation.
Your Honor,
Witness intimidation.
and I know I said this previously, yes, sir, but we are not accepting any proffer from this.
Okay, excuse me.
Witness intimidation.
Yes, ma'am.
This is witness intimidation.
Am disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is, or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between, that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue.
Oh, they're done. They're done. This case is over. This case is over. That's a mistrial.
What he calls fact.
Young Thug is
Put it out
walking.
there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter.
Young Thug walks free.
This is a
Young
matter
Thug is going
that
home.
did not have a right
You
to
stupid
be a part
prosecutors.
of, as this
And
was
the
a
judge,
matter
too, got
regarding
involved.
A civil contempt that the court imposed upon a person for not obeying the court's directive.
Ah!
The state
What is she talking about?
case that Mr.
What
Steele
is this
cited
lady
does
talking
not
about?
stand for the proposition. He asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who were not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our
Yeah, you guys are done.
concerns.
You tried to talk to the witness outside the presence of the defense.
Without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made.
You can't make it.
To them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, or the last 2 work days.
Appropriate remedy? Mistrial. Mistrial is the remedy. What are you talking about?
On the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him
Get the fuck out.
where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as we were getting there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And, Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity of someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained
Okay.
from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court, now having found Mr. Steele in, and if the court continues in
Yes.
that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information